The word hero is overused, but not in the case of 78-year-old Charlie Johnson. He is the real thing, a hero who is standing like a rock for his principles, defending property rights for all Americans. This Massachusetts cranberry farmer and Korean War veteran believes that patriotism means being willing to face down bullying bureaucrats in court. Charlie Johnson has been waging a grueling legal battle for his right to farm without federal micromanaging and crushing government fees. When he could no longer afford legal bills, Pacific Legal Foundation, America's watchdog for property rights, stepped in to represent him, free of charge.
Very happy that Pacific Legal has saved us. I have no conception of where we might be. We've pretty much, my son and I both, pretty much decided that we are not giving an inch.
PLF has now launched a special campaign, the Charlie Johnson Legal Defense Fund for Americans' Property Rights, to help underwrite litigation for the Johnson family's right to farm and for others like them. Charlie lives with his wife in rural Carver, about 50 miles south of Boston. He and his son Van are carrying on the family tradition. The family has been farming their land since the 1920s. After decades of growing cranberries, imagine the Johnsons' shock 5 years ago when federal regulators persuaded the court to fine them $75,000 for the shoring up of some existing bogs and creating some new ones. Incredibly, Charlie was fined because he didn't get federal permission before he improved his farming operation. He wasn't just fined. The court also ordered him to spend more than $1 million to restore areas where he had moved soil. What right did the feds have to tell Charlie how or where he could grow cranberries on his own property? Short answer, they did not and do not have this authority. The EPA cites the Clean Water Act to justify its assault on the Johnsons, but this rationale is all wet, especially in the wake of PLF's landmark 2006 victory at the Supreme Court in Rapanos versus the United States. In Rapanos, the court intended to rein in Clean Water Act bureaucrats, who have been trying to transform the federal government into a national zoning board, subverting local control over land use issues. In Rapanos, the court held that the Clean Water Act extends only to navigable waters, such as rivers and lakes, and nearby areas with a continuous surface water connection to navigable waters. In Charlie's case, the feds have never demonstrated any significant connection between water on his property and navigable waters elsewhere. They seem to be saying, we don't need to prove anything. And this is why Charlie Johnson's legal case is so important for the rest of us. In a real sense, Charlie Johnson is the canary in the coal mine. If regulators are allowed to ignore the Supreme Court and the legal limits on their power, Charlie Johnson and his family won't be the last victims of federal oppression. Sooner or later, all landowners and homeowners will be at risk. So if you value property rights, root for the Johnsons. And please consider a special gift to help PLF's fight for Charlie, because this brave farmer is fighting for all of us.